You're standing in your parents' kitchen. Your sibling just told you they want to keep the house, rent it out, hold it as an asset, but you want to sell. And the second you had that thought, you felt it because you knew, even if you didn't say it out loud, I don't want to keep the house. I just want to cash out. Now you're the successor trustee. The trust doesn't specify one way or the other, so the decision is yours. But you're also a beneficiary, and you have a financial stake in the outcome. Suddenly, things just got complicated. This role is more than just a responsibility. It can be a tangled web of duty and personal interest. So how do you make fair decisions for everyone, including your siblings or other relatives, when every choice could directly affect your own inheritance? That's exactly what this video is about. I'm Darlynn Morgan, and I've been an estate planning and trust administration attorney for over 25 years. And this situation, being named both a trustee and a beneficiary, comes up all the time in nearly every family trust that I help administer. This is a high-stakes position, and a lot of people get it wrong, leading to broken family relationships and legal trouble. But it doesn't have to be that way. So let's talk about what this dual role actually means and the 4 things that can protect you. Before we get into the balancing act, let's clearly define the 2 very different hats you're now expected to wear. Think of them as separate jobs with separate rules. First, let's talk about the successor trustee. Think of this role as the manager. You've been appointed to take over the trust because the person who created it has either passed away or can no longer manage their own affairs. As the manager, your job is to step in and follow the rule book, which is the trust document itself. This comes with a long to-do list. You have to gather all the trust assets, pay off final debts and taxes, manage any investments, and finally, distribute the remaining property to the beneficiaries, exactly as the trust says. The most important part of being the trustee is your fiduciary duty. It's a legal term, but it basically means that you have to act in the best interest of the beneficiaries with loyalty and impartiality. This is the highest standard of care in the eyes of the law, and it means your personal wants have to take a back seat to the rules of the trust and your duties to the others. Now, let's look at the second hat, the beneficiary. Much simpler. As a recipient, you're one of the people who gets money, property, or other assets from the trust. You're entitled to be kept informed about how the trust is being managed. And when the time comes, you're entitled to your inheritance. So, you're both the manager and a recipient. And this is where things can get tricky. Wearing both of these hats at the same time creates what the law calls a potential for a conflict of interest. As the manager, your duty is to be loyal and impartial to all beneficiaries as outlined in the trust. You have to protect the trust assets and make them productive. But as a recipient, you have a personal financial stake in the outcome. Of course, you want to get the most out of your own inheritance. This isn't just a theoretical problem. It pops up in very real and difficult situations. Let's say the trust owns the family vacation home. As a beneficiary, you might have sentimental attachments and want to keep it. Or maybe you need cash fast, so you want to sell the house for whatever you can get as quickly as possible. But as the trustee, your job is to do what's best for the beneficiaries according to the trust. What if your sibling, another beneficiary, lives out of state and they just want their share in cash? What if the real estate market is down? Selling now might be quick, but it could mean a lower price, which hurts everyone's inheritance. Your duty as the impartial trustee might be to hold on to the property, rent it out to generate income, and wait for the market to improve, even if that goes against your personal wishes. This creates a serious tension between what you want to do for yourself and what you must do for everyone else based on the trust rules. There are other conflicts that are harder to see, and it can be almost invisible unless you're experienced at identifying these types of conflicts. For example, if you benefit from the trust today, but someone else is to benefit from what's left in the trust tomorrow, then as the trustee, you have a legal duty to both, what we call the current or the lifetime beneficiaries, and to what we call the remainder beneficiaries. That's one of the hardest balancing acts in all of trust administration. The heart of your job is to always put on your trustee hat first. And the law doesn't care about your intentions. If your decisions consistently benefit you at the expense of others, then you can be held personally liable. There are 4 things, when done consistently, will protect you legally, protect the estate, and give you the best chance of getting through all this without destroying family relationships. The first one is transparency. Silence is not your friend. When beneficiaries don't know what you're doing, they will assume the worst, and suspicion will grow. So from the beginning, notify everyone that you're the trustee. And in fact, most states, there are formal noticing requirements. You're going to let them know that they have a right to a copy of the trust. And when you make a big decision, especially one that could look self-serving, document your reasoning and communicate it. We usually recommend that our trustees get written consent or send a formal legal notice for these important transactions. You have to be clear and also careful of how you communicate things. So instead of, I've decided to sell the house, you might say instead, I consulted with a real estate agent and a financial advisor. Both have confirmed that rental income would not cover ongoing property taxes, insurance, and maintenance costs. So selling now will generate the highest net return for everyone in the trust. So here's a written analysis. That's going to serve everybody better. The second thing, document everything. Every single action you take as trustee needs to be recorded. This is your number one protection. Keep records, log every decision and why you made it. Save every receipt, every invoice, every bank statement, and every email. After a call with a family member or an advisor, send a quick follow-up email summarizing what was discussed. Create a paper trail everywhere. You will almost certainly need to provide an accounting at some point. If you've documented from day one, it will be much simpler. But if you haven't, well, then it's very tedious and more time-consuming and potentially a lawsuit. The goal isn't just doing the right thing. It's being able to show that you did the right thing. The third thing is the trust document is your rule book. You may feel pressure from family, and you may have your own sense of what's fair or right, but set that aside. Read the trust carefully, more than once, from start to finish. It has specific instructions for how and when to distribute assets. If the trust says that a beneficiary doesn't receive their share until age 30, then they don't get it at age 28, even if you think they can handle it or they need the money now. Your job is to follow the exact terms, and if you deviate from those instructions, even with the best intentions, you can be held personally liable for whatever loss results. The fourth thing is to build your professional team. You're not expected to be an expert in law, finance, and taxes. In fact, thinking that you can do it all yourself is usually a huge mistake. A key duty of a trustee is knowing when to ask for help. You need a trust and estate attorney who understands the specific laws in your state. You need a CPA who understands trust tax returns, because trusts file separately and have their own deadlines. And if the trust holds significant investments, a financial advisor who can help you manage them prudently for every beneficiary, not just you. Those professional fees are paid by the trust, not out of your own pocket. And the cost of hiring these experts is almost always going to be less than the cost of making a mistake or defending yourself in a lawsuit from an unhappy family member. Being named both successor trustee and beneficiary puts you in a powerful but precarious position. It's legal and it's very common, but it's loaded with potential conflicts that can tear families apart if you're not careful. Navigating this dual role may be one of the toughest challenges that you'll face, but you can absolutely do this successfully. The key is to shift your mindset. You're a manager first and a beneficiary second. Your personal financial interest has to take a back seat. By approaching this role with diligence, impartiality, and a commitment to fairness, you can honor the trust that your loved one placed in you and protect family relationships and safely settle the estate for everyone involved, including yourself. Now, the next thing most people want to know at this stage is how to handle trust property after someone dies. The personal property, the house, the bank accounts. That's what I'll be covering in the next video. So click that now.